Pursuant to adjournment, God save the Constitution is on the court.
Good morning. Please be seated. Okay, that's party speaker announcements.
Robert, the appellate rescue concept. This is Jay Ministry with Foley and Larger and I'm going by adaptive.
Okay. Are you going to do the arguing?
Yes, Your Honor.
Okay. Jeff?
Your Honor, for the appellee and cross appellant sitting at appellant's table, I'm Jeff Nobles. I'll present argument. With me at table is my partner, Nick Stepp. My client is Hugh Reel, the Hugh Reel Corporation, and Mr. Stephen Peacock, the president of Hugh Reel, is here this afternoon.
So you're calling him Hugh Reel. That's what you call him at the office.
Mr. Hugh Reel. Hugh Reel.
Okay.
Hugh Reel.
Gotcha.
Houston Real Estate.
Gotcha. Oh, is that what that is? Okay.
I assume I've never been told.
Whatever.
Thank you, Your Honor.
Okay, let us begin. How many minutes are you going to reserve? 5. Okay, let me begin with a question. I got teased this morning for saying, well, you usually have the question out before you let them even get to the front. And that's because we don't want to hear a summary of the facts, because we've already had a full-throated conversation about the facts. So, my question for you is this. 1, did you provide a survey?
Yes.
2, that's a very important question. 2, did you believe that a relevant part of the contract was as follows: if existing survey is not acceptable to the title company, buyer at buyer's expense will obtain new or updated survey acceptable to the title company and deliver acceptable survey to the seller and title company within 20 days after buyer received notice that the existing survey is not acceptable to the title company?
Yes.
Okay. They're both just yes and yes?
Yes.
Okay.
Can I?
There's more,
Right.
as the court knows, there's more flavor and detail to survey and preliminary plat and things like that.
I have a feeling he's going to beg to differ with you, and I thought maybe you might like to expound on it about what got delivered.
So every existing survey that existed that was in Rescue Concepts' possession was delivered.
Can you tell us what record pages we can find those surveys?
I don't have that. The one of them, though, is actually attached to the contract itself.
Isn't that the plat, though?
That's the preliminary plat.
Okay, and then, is that what you're calling the survey, or is there separate?
There were other prior surveys.
Okay.
The issue that was raised in the trial court was the question, and there's unusual language here that was changed to the form. Instead of the existing survey, it says the existing survey dated after the effective date, which is essentially impossible. But the existing survey provision is when anyone buys property. If you're buying a house, the seller takes whatever they have and provides it. In this case, everything they had that existed on that day was provided.
Well, I just bought a house, and the survey was a big deal, and we kind of like sat quivering in our chairs to make sure that survey was going to be acceptable to the title company. So that's why I'm having a little issue with what you provided, which you say it was part of attached to the contract, but it wasn't a new and updated contract survey, was it?
An electronic was the most recent, and an electronic copy was sent to the title company on the 29th of September. There was no objection from either the buyer or the title company.
And this is the plat document that was sent, or something different?
Well, the plat document,
Okay.
which in the contract is called a survey. So the parties themselves, when they signed the contract, referred to that document as a survey.
Okay, what happens if, or what, I guess what would you, why is a plat a survey, or does that matter here?
It doesn't matter to the appeal.
Okay.
It certainly mattered to the underlying question for the jury, but we've, in this appeal, just assumed because of Hugh Reel's conduct after October 16, that you can assume a survey was or was not provided, either way. That the operative legal principle here is when a party allegedly breaches a contract, the non-breaching party has an election to either treat that contract as continuing, insist on performance, and themselves perform, or terminate the contract. That's the common law. It's what the Texas Supreme Court says in long trusts, in Hanks before that, in this court in Henry, the 14th in several cases. It is a bedrock principle, and that's where the two parties are sort of on two different planes.
So what would happen if we were to say that a plat and a survey are not the same thing, but at the point that they demanded further performance, the extension, they didn't realize that a plat wasn't a survey? Like, what happens then? Are they just out of luck?
Well, that would differ from the record, because
Okay.
the record was that Mr. Peacock did believe there was a breach as of the 16th of October of 2014, and in fact,
He listed a few different things that were the breaches, right? And none of those were survey. Is that correct?
yes,
Okay.
and he was asked a very specific question,
Okay.
and we've included in our bench book, it's actually tab 4. 4 and 5 go together. Mr. Peacock was asked whether did you ever request an extension of the feasibility period after you sent your first notice of breach? And the answer was yes. So he requested the extension of the feasibility period, which is a benefit to the buyer. It gives them more time. For the seller, they take the property off the market for a longer period of time. And as the court knows from the factual statements in the record, the length of the feasibility period was a hotly negotiated topic in the pre-contract negotiations, and they settled on 42 days. Mr. Peacock requested the extension. Now, there's been a filing recently in the last day, the bench book, that suggests that somehow it was my client, RCI, that requested the extension for 60 days. The tab 4 in the Appleese book actually says the opposite. Twice in that email, and it's DX46. Twice in that email, Mr. Peacock says he's the one that requested the extension. But here's why that is so important. And tab 6 in our book shows Hugh-Reel's agreement to extend the feasibility period. They amended the contract. It's the opposite of termination. It is a perfect example of continuing, of treating the contract as continuing.
But you lost at the trial court, and Mr. Nobles is saying that you've waived it because you've abandoned that or didn't respond to it.
And we certainly didn't abandon it. At every level, we've argued this.
Okay, well, I'll let him.
And it's really not controversial, Your Honor. Whether Hugh-Reel treated the contract as continuing is undisputed. In fact, I noticed in the filing made by Hugh-Reel last night, on page 2 at the top, he states,
Who's he?
Hugh-Reel's counsel, states that they have elected not to terminate the contract, and that their Hugh-Reel's election not to terminate the contract was not a waiver. We're not arguing that it waived the breach of 6B. We're arguing that it deprives Hugh-Reel of the ability to claim that they're excused from performance. That's the issue in the case.
I'm sorry, I know you were on a good flow, but I'm watching the clock and I don't want to miss this question. So, so what do you think happened with the jury, evidentiary-wise, that got them where they got them, if you have a theory?
It was an unusual trial. It's hard to know what got picked up. There's not a court reporter's record. There's a recording. There was a lot of things said in the court. There was a lot of limine violations. It was an unusual trial, and I can speculate, but I really don't know.
I'm not going to make you do that. I just didn't know if there was anything. I'm just, you know, especially the evidence concerning the survey / plat / whatever those documents were, which I'm still not super clear on, but you know, it seems obviously the jury obviously believed that it was not, that the proper documents weren't provided, so I didn't know just maybe the question will maybe be something I ask Mr. Nobles, but,
I would love to re-argue the case, but it doesn't matter
Right.
because the legal issue that we tried it on in post-trial was that by Hugh Reel admittedly treating the contract as continuing, and I've got 6 points that I want to give the court on how Hugh Reel treated the contract as continuing. It is the operative issue in this case because Hugh Reel said it was not going to pay the $100,000 originally due on November 7th, that it got the benefit of having another 7 days to do feasibility, did not pay it on November 14th. That's the answer to 2A. That is the only jury answer that should be and that needs to be set aside. I mean, there is no question that $100,000 was not paid that day. Period. End of story. And the only question is, did Hugh Reel treat the contract as continuing? 6 reasons. First, they concede that they elected not to terminate. That's the opposite of continuation. Second, they extended the feasibility period. They got a benefit, and they demanded and insisted performance from my client, which was give them another 7 days. Third, they actually filed a lis pendens, and it's tab I in the appellee's notebook. So in one of the cases, I believe it's Henry versus Nissan, the party claimed an interest in property. Well, we have an analogous situation here where a party under the contract later filed a notice of lis pendens, which itself is an affirmation that they did not terminate the contract. They sought the benefit by claiming an interest in the property, different than Henry in that it was not a deed itself, but they claimed an interest. An important point on whether the contract continued. 4, they sued for specific performance. So they sought the benefit of the contract itself. That is a definition of treating the contract as continuing. 5, Section 7C in the contract required my client and allowed Hugh Reel to enter the property, do studies, do inspections of the properties. That continued. And 6, if you look at DX46, which again is the tab 4 that is attached, you will see a chronology from late October, after October 16th, until frankly right before the termination November 20th, of various things that Hugh Reel is doing, all of which are completely consistent with treating the contract as continuing. And that's why the earnest money should be paid to RCI. You follow the contract. First of all, RCI is the only one that pled for that, and the only one that at the trial court sought the award of the earnest money itself. But the contract provides that if there is a breach by the seller, the buyer can either terminate and get their money back. So it's not throwing good money after bad. They can get their money back. Or they can treat the contract as continuing and they can sue for specific performance or money damages or both. But what they can't do is take that second option and themselves not perform. Period. End of story. And that's what happened. So they extended the feasibility period. $100,000 was due November 14th. Was not paid. That is a breach. And
Okay,
in fact,
let's hear Mr. Nobles. You're going quite a bit over.
Okay.
And I'll bring you back in just a minute.
Okay. Thank you.
Mr. Nobles.
Thank you, Your Honor. Justices, may it please the court, we disagree that they performed the contract for several obvious reasons. First, they didn't put a single witness on. They had no witnesses. Everything that you heard this morning or this afternoon is counsel argument, not evidence. Jury question 1 asked whether either party had failed to comply with the contract with an instruction on materiality like the PJC requires. The jury found that RCI had not complied with the contract and Hugh Reel had. There's extensive evidence in the record that the survey was a material, important part of this transaction.
Could I interrupt you for a
Yes,
moment?
please.
At what point did your client become aware that there was no survey? Was that before the 7-day extension or was that after? When did they realize? Because I know at one point, I believe Mr. Peacock referred to the plat as a survey. At what point did he determine that the plat was not a survey?
I can say that I wasn't at trial,
Okay.
and I don't believe that the record is perfectly clear, but I do believe that Hugh Real's position consistently was that the plat is not a survey, and that a survey is important because this is a 300-acre tract that had never been developed for commercial use. It was going to be used for a heavily commercial use involving a railroad terminal, the placement of easements, I guess mineral rights, and certainly other encumbrances on the property was crucial. And there was
But
testimony.
wasn't that, I mean, to me it does seem like it's pertinent that, there is this request for an extension of the feasibility period, which would seem to look like demanding continued performance despite the breach. Was your client aware of the breach at the point that continued performance was demanded, or it's just not clear to me?
I think the record is clear that there were emails exchanged on November 20th, 2014. That's Defense Exhibit 46, which it's clear that both sides were willing to extend the feasibility period for 7 days. To your point, Justice Ferris, the contract has a provision for default. Paragraph 15C says that if there is a material breach by the seller, Hugh Real has an option to either terminate or to seek specific performance, legal relief, which means money damages or anything else. So Hugh Real didn't have a binary choice between terminating the contract at the end of the feasibility period or expanding it. They had a third choice, 15C, which was to proceed towards performing the contract. And when this lawsuit was filed, its purpose was to compel the provision of a survey and to allow the other parts of the contract that needed to be performed to be performed.
Is there some reason though why the word survey doesn't really seem to show up, at least proactively from Hugh Real's side, until the second amended petition?
I think that there were a lot of things going on. There were numerous defaults that were asserted. One of them was the failure to provide a title commitment. Another one is the issue of the survey, which had been raised during negotiations over the issue of this plat not being a survey. And I will say that our brief, our cross-appellant's brief at page 7 and 8, details the evidence from 3 different witnesses on our side who explained why that was material. And I guess to step back, it was important because it's a 300-acre tract and a survey is very expensive. And the parties had agreed to divide the cost among themselves in the contract. And that included the price of providing a survey. The initial duty to provide a survey was on the seller. If they provided one and the title company wasn't happy with it, then the buyer had the obligation to procure a survey to correct the one that the seller had provided. The seller never provided a survey, and there is no provision in the contract that required Hugh Real to provide notice of a particular breach at the time it occurred.
Well, doesn't that maybe go to materiality? Like if this isn't coming up in the conversation at all?
Well, the jury found it was material. The evidence was that it was material. There was no evidence to the contrary that it was immaterial. There are counsel arguments here today that it was immaterial, but the testimony before Judge Davis was that it was material. And the jury's finding of a breach by RCI and not by Hugh Real means something in the law, and that is it was a material breach of contract, which then, as a matter of law, excused Hugh Real from further performance.
So then how do you characterize what happened next? So if they were, If they're excused from future performance, but they continue to perform, what does that mean for us?
At some point, they won't be able to perform because they won't have a survey. And the survey was a material need that they had. They might have reached a point where they had to decide, do we want to incur the cost of the survey, or do we want to demand that RCI pay for the survey? The contract guides the decision-making of the parties to come in after the fact at RCI, as RCI does, and to say that it doesn't really matter, it wasn't really material. The jury decided that it was, and the evidence was that it was material. At the time that Hugh Real filed its lawsuit, it wasn't very long after the feasibility period had ended. And the purpose of that lawsuit was to compel specific performance of all of their duties. Their duty to provide a survey, any other duties that they weren't providing, and finally, ultimately, the duty to sell the property to Hugh Real as promised. And the finding material breach excused performance by Hugh Real after the material breach that was committed by RCI. That is what that means. And we attached a Supreme Court case from 2017, I think, to our bench exhibits last night. It's at tab 3. And so I was going to say that there's a long story about why RCI is not entitled to the earnest money in this case. But there's a short version too. And the short version is a very short paragraph in the contract. And that is paragraph 15A. It allows RCI to receive the earnest money only if Hugh Real is in default. Question number 2, the jury was asked the question, did Hugh Real fail to comply with the contract? And the jury found that they had complied, or it failed to find that they had not complied. Instead, RCI had failed to comply.
So it's your position that even after requesting the feasibility extension and getting it, that your client still had the option to stop performance because of the prior breach that occurred before the extension of the feasibility?
Under the terms of the contract, that's correct. And they were communicating. I wasn't there. I don't know who knew what at the time, but they were communicating. The contract doesn't require any particular kind of notice at any particular time. The parties know what they're doing, and if they don't know, there's something to be said. But
what is the best case, and it may be this 2017 Texas Supreme Court case, for the position that one party can continue to demand performance while being off the hook for its own continued performance if there's a prior breach?
I think I have a case, Your Honor. This isn't purely responsive to your question.
That's fine.
There's a case we cited called Chalker Energy, a Justice Heck decision from 2020 at 595 Southwest 3rd, 668, where the point was made, if the parties agree to jiggle deadlines and to move deadlines, that is no evidence of an intentional relinquishment of a known right. It's an intention to try to work out a problem that the parties are having. This contract has built into it a provision that required the parties to try to work out the problems that might develop. That's what the evidence says was happening in that 7-day period. So if there is a waiver on Hugh Real's part, it's a waiver of the deadline for the feasibility period. But it's not a waiver of the need for a survey. So Hugh Real never intentionally relinquished its right to a survey. And I honestly read the brief of RCI in this case to not argue to the contrary. Their argument is about not who complied with the contract because they failed to comply. And they don't challenge the jury's answer to question 1. Question 1 on material breach is not challenged by RCI in any respect.
But if there is a duty to work it out, doesn't your client have the responsibility to say, hey, this isn't a survey? Could you give us a survey?
And I think that was asserted no later than November 20th of 2014. And I'll check the record, and that's my understanding. I also don't believe that's the first time the issue was ever mentioned. And honestly, the short story version of this is that paragraph 15A says that RCI gets the earnest money, $50,000. This is not the biggest issue in the case. RCI gets the earnest money only if Hugh Real has failed to comply with the contract and is in default. The jury was asked if Hugh Real had failed to comply, and the jury said no, they did not fail to comply. And that finding has not been challenged by RCI.
He's saying you did fail to comply by not depositing the $100,000.
And
That's what he's saying.
And that is certainly their argument. Under Texas law, their first material breach excused further performance by my client. My client testified why paying $100,000 after RCI had indicated that it was not going to comply with its duties was unnecessary. And under Texas law, because it was a material breach first by RCI, Hugh Real had no further duty. And that's an argument, I think, about question 1 in many respects, which isn't an issue in this appeal. The argument, I think it's question 3 that they complained that waiver and ratification were established as a matter of law. The cases say that's not what it is. And Chalker is the most recent case to say that that's not waiver or ratification. That's an attempt to move some deadlines so that people can talk. It's not a continuation of performance that waives Hugh Real's right to a survey. That's the right that was never waived. That's the duty that was never performed. I have 2 minutes left, and if I may, I'd like to talk about one issue in our cross-appellants brief, and that is Hugh Real was entitled to discovery that was denied on the eve of trial. This is a very important point.
Sorry, I didn't hear.
Sorry.
Oh, that's me. I thought that was you. Sorry, it's my paper on my microphone. Apologies.
We all do that all the time on Zoom these
I didn't even know
days.
it was. There, go ahead.
And I may take a little more time if I may, Your Honor, because the appellant had a little extra time. This is what I have to say about that. The issue here was that 1 month before trial, Hugh Real learned that this property, which had been held for RCI for 6 years, had been sold in August of 2019. That was a case-changing development because Hugh Real had sought specific performance in its lawsuit, and it expected its remedy for RCI's breach of contract, its material breach, would be specific performance. In December of 2019, Hugh Real's trial counsel filed a motion to compel the depositions of the principals to that sale and the production of documents related to that sale. And the trial court decided not to allow that discovery to happen. That was an abuse of discretion under Texas Rule of Civil Procedure 190.5. When time has passed since the discovery cutoff, more than 3 months, in this case it was years, and when there has been a material change in the matters to be tried, further discovery is necessary, and the trial court has no discretion to deny it. The trial court knew that the cutoff had happened. The only thing the trial court didn't know was the materiality to the lawsuit, and this is the important point. The materiality of the sale that Hugh Real made to a company called NPH was established later on by our discovery that RCI's counsel had stated to the court that nothing can change with this discovery, and that was not true. And that is a somewhat complicated statutory argument, that's stated in our cross appellant's reply brief. But basically, there was a property code amendment in 2017 that said that after 2017, the expungement of a lis pendens no longer can be relied on by a buyer like Q-Reel as an argument for why it has superior title to the purchaser of the property. RCI incorrectly argued, and we didn't know that the argument was incorrect, that the 2017 amendment applied. And the reason we didn't know it was because the argument was made that the 2017 amendment applies. And the facts were that RCI had represented that the expungement order was filed late in 2019 rather than in 2016 when it was. When we discovered this, it was between our appellant's brief and our reply brief. That's why our reply brief explains the materiality at this point. There's been a challenge to our first issue. Our first issue is that we were denied discovery. We can't know all the harm that we were denied, and the reason we can't is because we don't know what we don't know. When we can do the discovery, we will know what we didn't know.
What damages would that go to that you were seeking?
It would go to the
trial?
right to specific performance of the property. It would be an opportunity to join MPH as an additional party to this case, and a right to have the rights of the parties to the property decided. We were denied all that because the trial court was misled by a bad argument that was factually mistaken. We're not here to judge what happened, but there is an opportunity here to fix a problem. And the purposes of discovery, which are as much transparency as possible, would have been furthered by a correct ruling that sure, you can take 2 depositions and see the documents. And if you need a little more time, take a little more time. This case was delayed for a long time, but it wasn't Q-Reel's fault. This case was on appeal for 3 solid years, and that was not Q-Reel's fault. So, for those reasons, we hate to give up a jury verdict, but we request the court to reverse and remand for a new trial so that there can be discovery and all the facts can be disclosed and a fair trial can be held. And with that, thank you for your time.
Mr. Ministeri.
I'm going to address one issue on the sort of
Could you
breach.
speak up a little bit?
Of course.
Thank you.
Believe me, I can. If the survey was material and so critical, then immediately on the 16th of October, they would have known they didn't get it. And essentially, to try to claim that by the extension of the feasibility period on November 5th, extending it from the 7th to the 14th, and he's not claiming this, and the record differs, would be incorrect. The Q-Reel representative understood the contract. It said 20 days. That was October 16th. He either did or did not receive the survey. After that date, he treated the contract as continuing. Now, one thing he didn't do is he didn't go out and ask for a new survey on his own. He had a contractual right to go out and get a new survey. He had the right to enter the property. Instead of just alleging breach, if this was something, worth millions and millions of dollars, he could have paid $5,000. He didn't do that. Now, we made a reference to a title commitment. The title commitment was provided on the 12th day, not the 10th day. He's correct. It was not provided exactly, but they got it, and there was no complaint that somehow my client didn't actually provide the title commitment. Nor, once this dispute arose, was there any request for restraining order asking for the delivery of the survey. I mean, if that was the critical element here, you would have seen all that. And the reason you didn't is probably because it wasn't material, and what's going on here from a big picture, someone who didn't have money, wasn't ready, willing, and able to fund $12 million. He had to get another partner. He didn't have the money himself. He couldn't even pay the $100,000. He was trying to tie up the property, and that's what happened. He used whatever he could to sort of extend this on, and he took the position that he didn't have to pay the $100,000, and that really is at the core of this case, which is that at the end of the feasibility period, the $100,000 was due. If he had treated the contract as continuing after October 16th, which he did for the 6 reasons I outlined, then on November 14th, $100,000 was due. Notwithstanding what the jury found in 2A, that's question 2A, the evidence is conclusive that the $100,000 was not paid, and that's tab 5, where Mr. Peacock from Uriel is asked, you also didn't pay your $100,000 that day on November 14th, did you? Did not. There was no, the jury's finding is contrary to undisputed evidence, and it should be set aside. What's interesting, though, is the prior question in that tab, because you can't terminate a contract. You can't decide not to terminate a contract if it's continuing. And he's asked, my question was, did you understand that you had a decision point, a fork in the road, that after being given the 7 days, that you didn't necessarily have a right to, but my client provided, that when you came up to November 14th, you had a fork in the road, and you decided not to terminate the contract, correct? That is as forceful as it gets, that he had treated the contract as continuing from October 16th to the 14th of November.
I don't want to take up much of your time, but how do you distinguish chalk or energy?
That's what I was going to ask.
Well, I mean, Chalker's talking about a different type waiver. It's more like a Tenneco type question. This issue, so there's two, just separate the waivers. One is 6B, provide a survey, and we can assert affirmatively that the plaintiff waived the breach. That's not our position. Our position is that you waive, I think the court's word, this court's words, are you are deprived. Uriel is deprived of the ability to be excused from performance if it treats the contract as continuing. It's the waiver of the right to say I'm excused if I treat the contract as continuing. So Chalker, Tenneco, which is waiver as a matter of law, those relate to a different type waiver. Do I think that they waived 6B? I do. Did the jury find for my client? No. Does it make a difference to this appeal? No, because what we're talking about is this court's pronouncement, and I'm going to end with it because it goes again to the heart of this appeal. Uriel repeats as a mantra everything we all know and agree, and I'm reading from Henry, which is that is a fundamental principle of contract law that when one party to a contract commits a material breach of that contract, the other party is discharged or excused from further performance. Non-controversial. Everyone knows that. But it's the next sentence that he doesn't read. However, if after the breach the non-breaching parties continues to insist on performance by that party in default, the previous breach constitutes no excuse for non-performance. That's the issue in this case, and it's conclusively established they treated it as continuing.
Thank you for your arguments.
All rise.